the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning, everyone. It's good to see everyone today. Welcome to the October session of the Tennessee Court of Criminal Appeals. I know we have some visitors in the audience, and I want to welcome you. I know we have students, I think, from Fisk University. Welcome. And I know we have some participants in the Tennessee Bar Association's boot camp for today. So I want to welcome everyone. We always are pleased with the opportunity to have the public come in and see what it is that we do as the appellate court, or one of the appellate courts in the state of Tennessee. So let me get right to it. First things first, let's turn the phones off. That was perfect. That gave me the opportunity to say, please silence your phones. The panel for today includes Judge Robert Wiedemeyer. And Judge Wiedemeyer is our most senior appellate judge on our court. To my left is Judge John, and he's from the Middle District. To my left is Judge John Campbell, and Judge Campbell is from the Western Division in Germantown, Tennessee. And my name is Camille McMullen, and I too am from the Western Division from Memphis, Tennessee. And so for some of you all who do not know, the Tennessee Court of Criminal Appeals sits statewide. And that means that we travel to one of the three grand divisions that's in Knoxville. We sit and hear cases out of Knoxville. We sit and hear cases in Jackson, and we sit and hear cases once a month in Nashville. So you have a panel comprised of judges from across the state. So with that being said, the parties know that I see some very familiar faces. You know that each party gets 20 minutes per side. We operate on a light system now, so when you approach the well, please let the clerk know if you intend to reserve rebuttal time, and I too will try to help you keep up with that time. Madam Clerk, do we have any preliminary matters?
No, Your Honor.
Call the first case.
State of Tennessee versus William Darnell, Britton.
Good morning. 3 minutes for rebuttal, please. Good morning. I'm David Rabin, Davidson County Bar, representing Mr. Britton in his appeal from Davidson County conviction for murder in the second degree. At council table is Caleb Castle, who is Davidson County Bar, who was the trial attorney in this case. Imagine Johnny Cash is on trial for murder. And the prosecutor says, Mr. Cash, isn't it true you wrote a song saying you killed a man in Reno just to watch him die? Bob Marley's on trial for shooting a law enforcement officer. Mr. Marley, isn't it true you wrote a song saying, I shot the sheriff? Everybody in this courtroom not familiar with this case is saying, Mr. Rabin, what in the world are you talking about? That is ridiculous. Of course it is ridiculous. That is what happened to Mr. Britton in this trial. Among other things, he's a rap songwriter. He writes music. And charged with murder in the second degree, the prosecutor, over strenuous objections, said, Mr. Marley, let me talk to you about your rap music. Didn't you say things, and I'm not going to repeat all the N-words and profanity and some things in his rap songs, but the record's replete with this. I shot a man, I'm a murderer, it's a murder scene, all of this. This went on for pages. The only thing longer than that cross-examination was the objections of counsel complaining about this. I suggest that this case here today, and there are other cases in Tennessee which address rap music, but no case in Tennessee focuses on the issue as squarely as this. I suggest that this court's opinion will be a seminal decision in Tennessee and perhaps be known as the Britton Doctrine, dealing with rap songs. The facts are not in dispute. My client and his brother are sitting on a stoop, and some 20, 30, 40 feet away is the alleged victim. Words are exchanged, threats are exchanged. My client feels threatened, his brother feels threatened. My client pulls a pistol, shoots him, leaves. There are 6 different witnesses who gave 12 different stories about what happened out there. There's a videotape, and I defy anyone to see anything in this videotape other than there's a bunch of people moving around at 150 or 200 yards away. Mr. Britton takes the stand to testify, and the prosecutor wants to ask him about his rap song list. The judge says, well, we're not going to let the videos come in, but you can cross-examine him about what's said. That's some small consolation.
Mr. Raven, so one of the things that jumped out to me when I was reading the briefs, both of which were very well written, is there a material difference between the videos and the lyrics in this case? Why this trial judge, a very seasoned trial judge, specifically made a difference. He made a determination that videos, no, lyrics, yes.
Well, I suggest there's no material difference between one or the other. In fact, the videos, I think, you can actually, the cross-examination is more profound because a lot of the video, you can barely discern the words and that sort of thing. And it's a lot more powerful to ask the defendant over and over and over about these terrible lyrics and stuff. So I suggest there's no material difference. It's no less harmful to question him about that than to actually see him moving around on the stage or whatever. It's a distinction without a difference. But this went on for pages. Now, what in the world was the prosecutor thinking by trying to get this stuff in? The judge let this in under some theory that this shows intent or motive or proof of other crimes. I don't know. But what this case is, at worst, it's a manslaughter case. That's all this ever was, potentially. Now, what is the law here? Every modern American jurisdiction in the country over the last 10 years that's ruled on this has come to the exact same conclusion and set forth some legal criteria, which I suggest this court could adopt, as to the admissibility or non-admissibility of these things. Here's the way to analyze this. What is the proximity of the lyrics to the offense? Was the song created a week later or a week before? I'm going to get this guy, I'm going to kill Joe, or something like that. Did it happen weeks or months or years before? Ask the government when they get up here, when were these things created? The government will have no explanation. They don't know. Important is the issue of relevancy, which is an issue in every case. What is the nexus between the alleged crime and the lyrics themselves?
Mr. Raven, I'm going to stop you. I understand the case law that you relied on in your brief and that you're directing us to. And it didn't appear that that was presented in the way, obviously, in the way it's presented to this court, to the trial court. And I'll let the parties know we have read the briefs thoroughly.
Sure.
We've not done a deep dive into the record. We're not obviously as familiar with the record, especially as trial counsel in this case. But it appeared that the parties were going through, and if you could help us in understanding the basis for the introduction of the lyrics. The state sought to introduce this, and I want to make clear the grounds upon which they were seeking to introduce the lyrics in this case, and this was on cross-examination. And it seemed like they were doing it on 2 grounds: to prove his intent and to impeach him. So can you elaborate on how the trial court analyzed, or whether the trial court, because as you know, we are looking to determine whether the trial court erred in admitting or allowing the state to question the defendant on cross-examination about these.
Sure.
So those 2 things, if you could tell us how the trial court erred in allowing the state to cross-examine.
Well, I think it go back to the case law saying that where every other court tries to get this in under the theory of impeachment or intent, exactly what this judge did, saying, I think it's admissible because it shows his intent or proof of other crimes or impeachment of the defendant. And I'll go through each of those. Impeachment of the defendant only is for something, if it goes to proof of other crimes, saying, didn't you do this or didn't you do that? So there couldn't be that in this particular instance because these things had no nexus to this particular crime. The case law says if he says, I'm going to kill witnesses or something like that, sure, that is traditional impeachment. But just because a defendant takes the witness stand, and this is where the judge erred, is not open season on cross-examining the defendant about every possible thing that he or she may have ever done.
Mr. Rabin, let me just stop you for a second, because it seemed to me that the focus of this was you had this argument about self-defense, and your client was saying basically, I don't carry a gun except when I went to this housing project, whatever it was. And that kind of triggered this, from what I can tell, this argument that, well, in these rap songs, all he's talking about is carrying guns and doing shoot and stuff like that. And it seemed to me that was more of the focus, is the fact that he went in there and said, I don't carry a gun ordinarily, that the court was focusing on as far as these rap lyrics. Now that is what I kind of gathered out of it. So what is your response to that?
Well, first of all, they opened the door. They asked this question, like, when do you carry guns and all of this? And so the connection between, well, I don't normally carry a gun, and this rap music that he sings, okay, just because he's singing that does not mean that he himself carries a gun at any particular time, because it's art. That's the whole point when we get to the prejudice thing, and I want to answer the court's question. This is his art. This is not a statement that he's making about this offense. He's just singing a song. So just because he carries a gun or he doesn't carry a gun, that sort of thing. The other thing is about impeachment. This does not impeach the defendant. That's the simple answer to this.
So explain to us, I mean, for the benefit of those in the audience, in this case, the state argued that they sought to impeach, and I was trying to understand it, they sought to impeach the defendant because he gave an impression based on his answers that he was situational in carrying his weapon. And the state argued that they were entitled, and the trial court appeared to agree, they were entitled to impeach the impression that he was giving to the jury, as well as show his intent to be homicidal.
Okay. Well, first of all of this stuff that you're talking about was directed on cross-examination. There was nothing that the defense brought up on direct that in any way did this. So you're having the state ask a bunch of ostensibly inadmissible stuff and then impeaching him under the guise of impeachment where he's giving this impression. I mean, the case is all about what happened out there on the street corner. All they were trying to do was set this up so that they could get this stuff in. But let's talk about the cases that I've cited all go through this intent. And so what the court's asking is there's some theoretical possible relevancy there, maybe. But then you get to the question, there's two other issues. Prejudice. You weigh these two factors, and then you have the curative instruction and the prosecutor's closing argument. Talk about that at the end. In this particular case, the case law said this stuff is racial. If you look at the videos, everybody in this case is black. This case, these words are absolutely appeal to racial bigotry and prejudice and violence, and that's exactly what the case law says. That's why this stuff is not admissible. That's why I opened about with Johnny Cash. You never see that in this kind of case anywhere unless it's in these black rap songs. It's prejudicial. It's racial. It enhances this beyond description. So when you balance all this stuff out here, this defendant had an absolute right to testify what happened out there on the street. He did not get up there to be whacked with his music, his songs that have absolutely nothing to do with this. But when you balance this, This stuff is poison. It is absolutely outrageous to cross-examine somebody like this. And in this case, the state is the proponent of this evidence. They didn't ask for curative instruction. And I understand what the law is, that supposedly the defense has to do that. I don't believe in that doctrine. If the state is going to put on that kind of evidence, they have an obligation to try to mitigate that. Not the defense lawyer. That turns the law on its
So the
head.
defense attorney has no obligation to ask for a curative instruction? And if he doesn't ask for it, is it not waived?
That in this particular case, my position is I understand the law on this area. But I'm saying that when the state is the person who does this is not some witness blurting out an answer. This is where the state does this and there's no curative instruction given. Why should he try to mitigate the harm that the state has perpetrated on a client? Don't you think the judge would do that on his own? I know what the case law says. But the last thing is the prosecutor compounded the error by arguing this in her closing argument. And the state says, well, there's no objection to this. And the state says, how can it be error for the prosecutor to argue something that the judge let in? Exactly. Exactly. They walked right into that argument because the law there is clear. When you compound an error by a closing argument, you make it worse, and you eliminate the possibility of harmless error. So I suggest here, under all the case law from everywhere in this country, if you read all of them, and there are a lot, the cases are a lot worse than this one in the sense that the nexus between what you're talking about, Your Honor, and the crime is much, much closer than this case where it's nebulous completely. They still reverse it because of the racial component and the prejudice here where you have absolutely no reason to do it. The last thing I want to talk about before I run out of time here is the failure of the judge to charge the jury on defense of another. In this case, the defendant testified, I was protecting myself, I was protecting my brother who's sitting literally right next to him, and his brother testified, I was scared, I was afraid that we were going to die. That's the proof. There was no charge of defense, no self-defense was charged, but there was no charge to the jury on defense of another.
On this issue, the trial court agreed that it was a close question. It was a close question. And the trial court went through the evidence in its motion or in its order denying your motion for new trial. But it ultimately determined that there was no way that the defendant knew that or was aware of his brother, the protecting of his brother piece. Went through a lot to try to explain why it felt like, even if it was error in this case, it was harmless because the defendant shot the victim in this case 7 times, 2 times in the back, with evidence that it appeared that he shot the victim while the victim was incapacitated. Those were the trial court's words. So speak to the harmlessness or the prejudicial impact of it.
First of all, I've never seen a case in Tennessee that holds that it's the failure to charge self-defense or any defense, which is raised by the proof, is harmless error. There isn't any. There aren't any cases which say that. And there's no such thing as a close question. If there's any proof in the record that a reasonable, if it's fairly raised by the evidence, it doesn't matter how overwhelming the state's case may be. That's not the test. The only test is whether or not there was proof in the record, which there was, to reasonably raise the issue, and there certainly was. This, what the judge said, is ex post facto or retroactive justification for what he didn't do in this case. There was no finding in the trial court while the trial was going on about all this. The case laws couldn't be clearer. This case of 1880 talking about this, where if you got a defense, now maybe the jury said, well, maybe the defendant wasn't defending himself. Maybe. But he could have been defending his brother. You have two separate defenses. And in this case, that was not given. I suggest, Your Honor, it cannot be. If it's a close question, the tie goes to the runner. The defendant gets the benefit of that. That's what the law is in Tennessee. There's no such thing as harmless error on failing to charge. It's a constitutional error, I suggest, because the defendant has an absolute right to have all these facts presented to the jury. They just missed it. So if you add that along with the other instructional errors, along with the sin of this rap lyrics, you've got a conviction that cannot stand. This conviction, and we're convicted of second-degree murder, and the difference between second-degree murder and manslaughter is razor thin. In fact, there's more elements for manslaughter. If this was a first-degree murder case, I don't know that I'd have much to argue about. But it's second-degree murder. And if they hadn't put that rap music in there and had charged a self-defense thing like I'm asking for, who knows? It's presumptuous to say, oh, well, the jury would have done this and the jury would have done that. They went to second-degree murder on exactly what Your Honor said. Oh, he shot him 7 times. He shot him in the back. Doesn't that sound like first-degree murder? Sure does, but it wasn't because of the evidence in the case. So I'll save the rest of my argument for rebuttal.
Thank you, Mr. Rabin. General?
Good morning. May it please the court, Lacey Wilbur on behalf of the state. Your Honors, Johnny Cash was never asked if he shot a man, and his lyrics were true because he was never on trial for murder when it was undisputed that he shot the victim 7 times, twice in the back. It was undisputed that he committed this murder, and the jury properly convicted him of second-degree murder. With respect to the introduction of the rap lyrics, as Your Honor knows, this was a very experienced trial court, and he weighed the probative value of it and found that it was probative. He didn't specifically say it. He implicitly.
Yeah,
he
because I read the portion, counsel put in an appendix, and that enabled me to quickly go through.
It's implicit.
Okay.
Yes, Your Honor.
So that's really difficult when you have something as inflammatory as rap lyrics. And what you're asking this court to do is read into what the trial court was doing. This clearly was a very hotly contested issue between the parties. And so for the trial court to sort of jump over the steps on this is troubling. Do you agree?
I agree. I wish that he had done a more explicit, but what we have, and that helps our argument, is that the judge specifically found that the videos were not admissible because of prejudicial value.
And so that is why I was asking, is there a material difference between videos and lyrics?
Yes.
Because I didn't understand why he made that distinction. He said, this is clearly inflammatory, these videos, but the words aren't?
The videos, from what the judge was narrating from what he saw on the videos, was that the defendant was holding automatic handguns, weapons, assault rifles, and that there was a child holding an assault rifle. And then the judge was like, that's just way too prejudicial. But the judge allowed the rap lyrics because the defendant himself put his credibility at issue when he said, I only carry my gun when I go to the projects. He's giving...
That is not what the prosecutor said.
The prosecutor wants it to go to his state of mind
Character.
and to impeach his credibility. She says both, but mostly for her part, she was saying it's his state of mind. And his state of mind was that what he presented to the jury was that he was a peaceable character who only took his gun to dangerous areas like the projects. But what his rap lyrics and what the state was trying to show, and that the trial court properly allowed, was that the defendant was enamored with guns and that he did not have any problem about taking weapons with him. He took weapons with him wherever.
It sounds like the state is trying to kind of pigeonhole an exception that does not exist.
This is just basic relevance, and did the defendant put his character at issue when he testified that he only carried the gun?
So you're mixing character and credibility. Did he put his character at issue?
He did put his character at issue.
How?
When he said, I only carry my gun when I go to the projects.
How is that a character trait?
He's saying that he's a peaceable person.
Was that,
Oh.
was that in response to questions from the state during cross-examination?
Yes, Your Honor. And when the defendant chose to testify, he opened himself up to cross-examination, and that was proper. And then that opened the door when he did not, when he said, I only carry my gun when I go to the projects. And again, I'm not saying that this was a fantastic decision, but it was proper. It was not an abuse of discretion. That is the standard of which we are under.
Well, let's go back to what counsel was saying, is that if this is his art, he's making a song, does that mean that his life followed his art? I mean, in other words, does that mean he carries a gun all the time?
That is a question for the jury, Your Honor.
But is it proper to use the lyrics to basically make a statement that we don't know whether there's any truth to?
How is that not rank propensity? That is just,
It is a question of impeachment and credibility that the jury determines. And
but if it is art, it is not
art is,
fact.
art is autobiographical in some instances. As Your Honors know, Taylor Swift fans just parse every sentence and lyric in her songs, and the jury was allowed to do the same in this case, because songs are not written in a vacuum. Songs are written with context and with your life and your.
None of which was established in this case. We don't know when these songs were created. These songs really have no connection. There was not even an attempt by the state to make a connection between the songs and this particular offense. Is that not too problematic?
It's certainly getting towards the line, but is it an abuse of discretion for the trial court to allow it in? And our answer is no. But if this court finds that it was problematic and that it was an abuse of discretion, it was harmless error, because the jury found the defendant guilty of the lesser included offense of second-degree murder, which is a knowing killing. And because the state was trying to show his state of mind and his character for carrying guns everywhere, the jury obviously did not agree with that and convicted him of the lesser included offense of second-degree murder.
So was his state of mind still not in question on second-degree murder?
Yes, Your Honor.
So I don't see how that alleviates the error.
It alleviates the error because the state was trying to get it in to show premeditation and that he was obsessed with guns and was wanting to kill people. And the jury rejected the premeditation and found that it was a knowing killing. And again, I just want to point out the facts again to this court, is that the defendant, he says he was scared, but even though he was scared, he goes to the middle of the street, shoots the victim, then walks further across the street, shoots him another 6 times. He shoots the victim a total of 7 times, twice in the back. And when the defendant was asked, how do you explain that
I agree, Ms. Wilbur. The facts in this case are egregious, and that's a problem for the defense.
Yes.
But even in Rucker, upon which I think both parties went through a great analysis of, this court reversed with overwhelming evidence of guilt. So
And
that is where I am. I'm trying to figure out
Sure.
the prejudice.
In Rucker, the trial court said, prosecutor, you may not refer to these Facebook postings at all. And at closing argument, the prosecutor referenced the Facebook statements and the Facebook postings. And this court found that that was prosecutorial misconduct during closing argument. In this case, the trial court said, you can put this evidence in. And that is what the prosecutor did. So Rucker is completely different from what we have in this case.
I guess I was more so speaking to the fact that I think Rucker had there were 2 defendants, maybe 3 more defendants involved. And in analyzing the prejudicial effect, this court recognized that there was overwhelming proof of guilt. But we reversed anyway, because not only did the prosecutor commit prosecutorial misconduct, but we talked about the racial inflammatory nature of the lyrics. We talked about the fact that there was no temporal connection, not even an effort to make a temporal connection with the lyrics. So there were other things in there that we talked about that should have signaled not only the trial court, but the state, that tread carefully in this area when attempting to admit rap lyrics, a form of entertainment, into your case.
And following up with that, in this case, from what I can tell, the victim and the defendant didn't know each other.
Correct.
Absolutely no reason why there'd be a beef or anything else going on. It was kind of nobody could really explain why there was this confrontation. So clearly, the lyrics, there was nothing in the lyrics that focused on an individual, like, this, I'm gonna get this person, whatever it is. These were two strangers.
Yes, Your Honor.
Do you want to follow? Ms. Wilbur, if you could help me, General Wilbur, I apologize.
That's okay.
So, we review the order of the trial court denying the motion for new trial, really to see what the trial court's reasoning thoughts were for ruling as it did during the trial. So the trial court here went through and did a pretty good job of analyzing the issues and telling us its reasoning, but on at least 3 occasions, the trial court agreed with counsel that it had erred. I'm not going to go through all that because the briefs are fairly extensive on all the issues raised. So if you've got at least 3 issues where the trial court concedes, yes, this is error, but I find it harmless, is that a problem for the state in this case?
No, Your Honor, because we're all humans, and trial judges and appellate judges are human, and they will make mistakes. And I really liked what the trial court said at the conclusion of that order denying. It said, errors were made. I am human. But do these errors warrant reversal? No. And one of those errors that he admitted that he did was on the omission of the distinction between involuntary manslaughter and second-degree murder in the second-degree murder jury instruction, but he did give that distinction in the involuntary manslaughter.
But with the acquittal first,
Yes, and this.
that doesn't count?
I cited
We've said that?
This court has said 3 times, when that omission is made, but it is made later in the involuntary manslaughter jury instruction, it is harmless error. And that's in the 3 different cases from 2017 through 2006 that
We have some cases saying the opposite too.
Yes,
but-
yes. They're all unreported, so I
Okay.
invite you to.
I understand.
To please publish a case to help us out on that split, yes.
Understood, and we hear you.
The other final issue that Mr. Rabin talked about was defense of another. And again, the trial court said this was close, but it didn't rise to it. And what we have on the facts is that Mr. Garrett, I believe it was, his brother said, I was scared. Well, he never communicated that to the defendant. The defendant didn't know that. And what we have in the defendant's own words is the defendant telling his brother, go. And then after that is when the defendant took it upon himself to walk across the street and shoot the victim 7 times. So the defense of another was not warranted. And as the trial court noted, because the jury rejected self-defense, it would have obviously rejected defense of another. And so I'll rely on my brief for the remaining issues unless this court has any questions, and we ask that you affirm the judgment of the trial court. Thank you.
Thank you, Ms. Wilbur, General Wilbur. Mr. Rabin.
Your Honor asked a question about the videos. Closing argument of the state. Quote, I asked him about them yesterday, and some of the songs that he chose to write and some of the videos that he chose to produce where he's talking about killing season, etc. The videos weren't shown, but the prosecutor certainly referred to videos in her closing arguments. Your Honor pointed out there were 3 errors that the judge pointed out here. You got 3 errors this judge struck out. You got 3 errors here. You can't have harmless error in that magnitude. Your Honor identified exactly the issue here about these rap lyrics. It's propensity evidence, pure and simple. And there's no way to get around that. Peacefulness, all that sort of thing. Remember, one of my issues here, the judge never charged first aggressor in the case. That's part of the pattern jury instructions about first aggressor, how you weigh that evidence with first aggressor rule. There was no instruction on anything about first aggressor.
What are you asking us on that issue, Mr. Rabin? Because was the trial court correct in assessing your argument that the first aggressor would only come into play if the state introduced evidence, or rebuttal evidence to your evidence that the deceased was the first aggressor? And the state's evidence, the only evidence that could have been perceived as rebuttal, was your alleged improper propensity?
Because the defense in this case put on tons of evidence about the non-peacefulness of the alleged victim in the jail. There was a huge amount
I understand, but what the trial court said was, the way the rule works is the state gets the opportunity to rebut. And the trial court reasoned they really didn't rebut, so the instruction wasn't warranted.
Well, to the extent that we put on evidence that impeached the victim, so to speak, and they put on this rap stuff.
So it is the rap stuff that you're relying on?
Yeah, sure, the rap
Okay.
rap stuff did it. The abuse, I understand it's a matter of discretion, but at some point, you get beyond that where legal rules. This case, Your Honor, I will end as I began. Respectfully, if the court would just ignore this or affirm this, it'd be the only case that I could find anywhere in the country, Georgia, Texas, Iowa, really serious sets of facts, more egregious and closer in nexus, reverses these things. And they just say, we're done here. This is not coming in an American court unless you can show that these rap lyrics have a direct nexus to this victim, knowing the victim from beforehand. Your Honor's exactly right. These people didn't know each other. Without that kind of evidence of a strong nexus to show intent, to show that sort of thing, like any confession. And in my reply brief, I cited even more cases. Absent that, that's reversible error per se. Thank you.
Thank you to both the parties for extremely good argument and very well briefs. We will take the matter under advisement. For the guests in the audience, we don't issue typically an oral decision on cases, especially cases of this magnitude. We will issue an opinion, a written opinion, within the next no more than 3 months. So analyzing all the issues to the parties. So thank you. Madam Clerk, call the next case.
State of Tennessee versus Mindy Powell Neal.